Good evening, everyone. I hope you can hear me okay. I apologize. I've taken off my coat and necktie, and so as a lawyer, I feel naked. But I, but I certainly hope that given the circumstances, it'll be okay. And I want to thank the Liberty Forum and in particular Erica Amirati for having John Cameron and me here to speak with you this evening about property rights in the United States Supreme Court and beyond. And this evening, I'd like to focus on three cases in particular that have either just been decided or are ongoing that I think will have a significant impact on the property rights of all Americans, including here in California. But before I get to that, I want to go over a little bit about Pacific Legal Foundation just to give you some context as to why we do what we do, but then go right into the cases, and I'll start with a case that's pending right now in the U.S. Supreme Court. And in fact, in working with Erica and preparing this presentation, I thought we might even have a decision in this case, Nick versus Township of Scott. It concerns the ability of a private property owner to sue a local government in federal court when that property owner says that the government has taken his property without just compensation. Second case is a case that Pacific Legal Foundation won just last year in the U.S. Supreme Court, along with other property owners, concerning the Endangered Species Act and the extent to which the Fish and Wildlife Service can use that law to restrict your private property rights. And the third case is one that's going on right now in the California Court of Appeal concerning the California Coastal Commission and the extent to which that state agency can impose crushing penalties and civil fines without first having to go to court and get a judicial approval for those fines. And then to finish off with some questions, and if I'm too legalistic, John Cameron can provide translation to to make sure that everyone understands if I've gotten into too much of a legalese. But basically, what is PLF? Our mission is two things. One, to win, and to win, secondly, big, that is at the appellate level. Our mission is we select cases that we think can tell a great story and that also help to vindicate private property rights and other constitutional liberties. And the idea is not just to win on behalf of the individual property owner or the individual citizen, although that is obviously top priority, but to do so at an appellate level, and ideally at the U.S. Supreme Court level, because if you can win at that level, then you produce a benefit that goes not just to the parties to that case, but goes to all Americans through the principle of precedent. A precedent at that level applies to everybody, whether you were involved in the case or not. And so we like to target our resources to find those good cases with good stories that establish those good principles, and I hope some of the cases that I'll speak about this evening help to illustrate that mission at work. And I again like to start off with a case that's pending right now in the U.S. Supreme Court. In fact, we may have a decision possibly on Thursday or certainly by the end of this month. Nick versus Township of Scott. You see pictured there our client, Miss Rosemary Nick, along with my colleague Dave Bremer at Pacific Legal Foundation on the steps of the Supreme Court building in Washington just after oral argument in October. The case was re-argued in January. More on that later as to why it was re-argued. But what is this case about? Well, Miss Nick and her family bought a 90-acre parcel of farmland in rural Pennsylvania, eastern Pennsylvania, in about 1970. And basically, she's lived on that property to this day. There is a single-family home on the property. She lives in that home by herself. The rest of the property is basically pasturage for horses and other livestock. And like most property owners, she has around her property fences and gates and signs that say no trespassing because naturally she values her privacy as a property owner. Things were fine in the town until about 2008 or so. She got word that at the town council meeting there was discussion that she might have on her property an ancient burial ground. Now, in this part of the country, in Pennsylvania in particular, there's a tradition of backyard family burials, that it's allowed that you can bury your family members, at least it was allowed to bury your family members on your own property. And so there is this tradition that there are old cemeteries. But when Miss Nick heard about this and the town council talking about this, she did her own research. Nothing in her title said there were any cemeteries on her property. None of her own independent research showed any cemeteries or any gravestones. And moreover, her own experience living on the property for decades, she had never seen anything like that. So she thought, no problem. Well, then again, things came to a head a few years later when the town passed an ordinance in 2012. And this ordinance did two things. One, It gave the right of town officials to go onto anyone's private property without their approval to look for ancient burial grounds. And two, it said that if the town found what it thought were burial grounds, the public then had an automatic right to come on any time during daylight onto your private property to go look at those alleged private burial grounds. And not surprisingly, a few months after that ordinance was passed, Miss Nick received a notice of violation from the town, saying that without her knowledge, town officials had come onto her property and had discovered, you see the arrow there, I don't think there's a burial ground, but somebody thinks there's a burial ground, discovered what they thought was a burial ground that triggered the ordinance's requirement that now Miss Nick had to leave her property open during daylight hours for the public to traipse across her property without her permission. Now, as you can imagine, this was a pretty significant intrusion into her privacy rights, but also, frankly, into her right of private property, because the most essential aspect of private property is the right to be private, is the right to keep the public off if you don't want the public on your private property. So she filed a lawsuit in state court in Pennsylvania, and she said, this law is unconstitutional, among other reasons, because it takes my private property without just compensation, in violation of the Fifth Amendment. And the state court said, well, you know, you have a decent argument, but I'm not going to address it right now because I think it's not ripe. I think we should wait to see if the town actually brings an enforcement action against you. And if it does, then I'll address it. But until then, I'm not going to go forward with the case. So Miss Nick, reasonably enough, said, well, I want a decision now. So she refiled her case in federal court. And that's where the issue really becomes interesting. She files in federal court, and the federal district court dismissed her case immediately, and the Third Circuit Court of Appeals affirmed the dismissal. And what Miss Nick had run into is a problem that property owners throughout this country have had for at least 3 decades, and it's called the Rule of Williamson County. The Rule of Williamson County is from a case from the Supreme Court from the mid-1980s, Williamson County versus Hamilton Bank, which boils down to this. If you're a private property owner and you contend that your local town or county has taken your property without just compensation, and you contend that violates your constitutional rights, you can't go into federal court first. You first have to go through state courts. Now, you might think, well, you know, what's the big deal? So, I mean, it's like an exhaustion thing. You have to litigate in one place first before going to federal court. What's the big deal? Well, there are at least 3 big deals. The first one is that property owners don't have unlimited budgets. So to say that someone has to litigate through an entire state court system first oftentimes means that there'll be no money left to do any litigation in federal court. Moreover, there is a problem of claim preclusion, the idea that in the law you only get one bite at the apple. You're not allowed to sue twice over the same claim. So you bring your constitutional claim in state court and you lose, well, then you refile in federal court. More often than not, the federal court will say, sorry, no 2 bites at the apple. I'm not going to hear your case. And the third big problem, and this I think is oftentimes overlooked, is that why do you suppose that the local governments want to stay in state court as opposed to going to federal court? Because state courts tend to be very deferential to local governments, whereas federal courts tend to be a little more independent-minded. So it's a question of where's the best forum in which to litigate your constitutional rights. And so Pacific Legal Foundation took over Ms. Nick's case and asked the Supreme Court to take it up to eliminate this rule, to eliminate the rule that you have to go to state court first before you can go to federal court. Now, there's some legalese on that slide, but the main takeaway that I want you all to have tonight is that ultimately, where you're able to file your federal constitutional claim oftentimes dictates whether you get any relief. And secondly, this rule that PLF is trying to overturn is unique. There is no other constitutional right in which a property owner or a citizen must go to state court first before bringing a federal lawsuit. And so this Williamson County rule has a perverse effect of getting courts to think that property rights are somehow a second-class right, that they're not as important as our other constitutional rights, and therefore it's okay to impose all these additional limitations on a property owner before vindicating those rights. And so that is the goal of the case, is to get the Supreme Court to eliminate that rule and to allow all property owners to go straight into federal court. Now, I mentioned at the beginning that the case was argued twice. And here's a little trivia question. The first time it was argued was October, the first week of October of last year. Now, why do you suppose that the case might have needed to be re-argued, even though it was argued the first time, the first week of October? Absolutely, right. So, so when cert was granted in the spring of last year, there were 9 justices on the court. But the first week of October of last year, the Supreme Court only had 8 justices. And so I think the fact that the court ordered re-argument for January means that it's a very close case, that probably the initial vote was 4-4. And the court, rather than wanting to send it back to the lower court without a decision, decided to have it re-argued. The Supreme Court's term ends this month, so definitely by the end of the month we'll have a decision, but I'm hopeful, having read the transcripts from both of the oral arguments in this case, that we will have a decision that will at least make things somewhat better for property owners. And again, this is an example of how it will be a win for Ms. Nick in her attempts to overturn this ordinance that forces her to open up her property to strangers, but it will also help every other person in this room who has any constitutional claim grounded in one's property rights against the local government because of the principle of precedent. Now, from a pending case to a certified win, I'd like to move now to an Endangered Species Act case that PLF and its allies won in the U.S. Supreme Court in November of this year, a case in which we won 9-0. And the case concerns the scope of the Endangered Species Act and how that law can limit the rights of private property owners. Now, how many in the room this evening have any experience with the Endangered Species Act? Very few. And that's not uncommon because oftentimes if you don't have property in a rural area or in an area that's being developed, you may not have a run-in with the Endangered Species Act. But if you do, the Endangered Species Act can be one of the most significant obstacles to reasonable and productive use of private property that federal law imposes. And for our clients in the dusky gopher frog case, it was a significant burden. So the dusky gopher frog you see there on the screen, it used to be found throughout most of the southern Gulf states, and it has kind of unique habitat requirements. And you'll forgive me if I go into a little detail on the biology, but it'll help to clarify the legal issue later on. So the dusky gopher frog needs basically 3 things to survive. It's a very particular frog. One, it needs ephemeral breeding ponds. Now, they have to be ponded because the tadpoles need water, but they can't be permanent ponds because that would allow predator fish to develop who would then eat the tadpoles. So there only has to be water in it for a certain amount of time in order for the ponds to work. Secondly, the gopher frog needs an open canopy forest cover. Open canopy because you need light to fall down onto the ground to promote the growth of grass and insects, which the frog eats. Also, the grass helps for the frog to lay its eggs. And finally, you need a way for the frog to get from the grassy area to the breeding pond. Okay, so that's the biology. Now, because that's kind of demanding, perhaps it's not too surprising that the gopher frog isn't doing that well. A lot of its habitat has been, frankly, has been developed over the last 50 to 70 years. And because of that, the Fish and Wildlife Service in 2001 decided to protect the frog as an endangered species under the Endangered Species Act. And a few years after that proposed critical habitat for the frog. Now, critical habitat is essentially, as the name implies, habitat that the feds think is important for a species to recover. And critical habitat, if your property is considered critical habitat, can have a significant impact on what you can and cannot do with the property, a significant negative impact. So when the Fish and Wildlife Service decided to designate habitat for the frog, the gopher frog, it made an initial proposal which was reasonable enough. It said, okay, the frog's only found in 4 places in Mississippi. Well, we'll designate those 4 places as critical habitat, and that's enough. However, several scientists and their environmental organization supporters objected to that idea and said, no, it's not enough that you just designate the areas where the frog is found. You should also designate areas where the frog is not found, just in case there is a frog apocalypse and you need to do some emergency transfer to save them. You've got to preserve some potential habitat. And so what did they do? Well, the service started looking around and said, hey, Here's a 1,500-acre parcel of private timberland in Louisiana. The frog hasn't been found here since 1965. There is no open canopied forest. There is no habitat requirement for the frog other than a few breeding ponds that we think might work. And so we're going to designate the entire 1,500 acres as unoccupied critical habitat. Oh, and by the way, according to our own economic analysis, the negative economic impact of that designation may trip up to $34 million, for which you get no compensation. You being, among others, the family, the Poitevin family, who owns the land and who leases it to the Weyerhaeuser Company for timber harvesting. It's a loblolly pine timber harvesting property. I'll back up there. That's Edward Poitevin on the right there with our attorney Mark Miller, who helped to prepare the case for the Supreme Court. Anyway, so not surprisingly, this caused a lot of controversy. And so the family landowners, thank you very much, the family landowners filed suit, and PLF represented those landowners along with a Weyerhaeuser represented by other able attorneys challenging this designation. We lost in the trial court and in the Fifth Circuit Court of Appeals, but were able to get the Supreme Court to take up the case. And there you see an example of excellent timberland but bad frog habitat. Able to get the Supreme Court to take up the case, and in November of last year, the Supreme Court ruled 9-0 that we were right and the feds were wrong. On the most important point, which is, as even the Fish and Wildlife Service acknowledged, if you were to drop the dusky gopher frog on our client's property today, it could not survive because it's an active tree farm. It's not designed to support the frog. And so how can you then say that this is habitat, much less critical habitat for the frog's recovery? So on that point, the Supreme Court was unanimous. Also unanimous, the Supreme Court was on the claim that the property owners had on the basis of excessive economic impact. As I mentioned earlier, even the service's own figures said that the impact could run negatively up to $34 million because of the increased permitting burdens. But even with all that negative economic impact, the service wasn't able to quantify any benefits. Zero benefits. And so our argument was, well, that seems irrational. Why would you do something for no benefit and for significant negative economic harm? And the Supreme Court said that's a valid claim that you're allowed to press on remand. Now, there were a few things you see on the slide there that the court didn't address, and those ultimately may be decided on a remand or they may be decided in other litigation. But I think it's fair to say that the decision already is a backstop against which the service cannot go farther. And I'm happy to say that the Trump administration's Fish and Wildlife Service has taken the cue and has proposed new regulations that would, to some extent, remedy this problem. And I think it's in part because of the victory in this case that gave the administration the ability to go forward with some of those remedial measures. From a win to a case also still pending right here in California concerning the California Coast Commission, the last case I want to talk about this evening, Lent versus the California Coast Commission. You see there our clients, Warren and Henny Lent, landowners or homeowners in Los Angeles County. Who here, by a show of hands, has any experience with the California Coast Commission? A few hands. Well, I can tell you again, this is one of those agencies where if you have property in the coastal zone in California, not only do you know about the Coastal Commission, but I think it's fair to say that you would say it's a very aggressive and a very hard to work with agency. And unfortunately, the Lents found that out the hard way. So the Lents purchased a single-family, two-bedroom home along Pacific Coast Highway in Malibu in 2002. And of course, when they purchased the home, they did their normal due diligence, no history of violations in the title. Everything seemed appropriately permitted. And everything was fine until 2007, when out of the blue, the Lents received a notice of violation from the Coastal Commission. And what this notice of violation said was that they had an improper or an illegal blockage of a public easement that ran along the side of their home. Now, there's a picture you see on the right there, the horizontal arrow, that's the Lents home. And the vertical arrow there is the alleged public easement. Now, the Lents were surprised by the notice of violation, to say the least, because they had seen no evidence that they were violating any public easement. But more importantly, and you'll see here, this is the actual existing public easement. It is a county-owned storm drain that is 7 feet below the grade of Pacific Coast Highway, at the end of which of storm drain there is another 14 feet to the beach below, or sometimes just to the water in high tide. So in other words, there is no public access. And that's one reason why the Lents had, when they purchased the house that was already installed by prior owners, a fence and a gate to keep the public from falling off the beach onto this undeveloped public easement. Well, no matter that the fence and the gate were necessary for protecting public safety, no matter that this public easement is not even actually accessible to the public, the Commission still said you have to take out everything. You also have to take out a second-story stairwell that partially encroaches upon that easement, and you have to do so immediately. And the Lents position was, well, we think we do have a reasonable basis to say that what we have here is appropriately permitted, that there is no violation, but for the sake of compromise, we'll be willing to take out whatever you think we should take out, so long as you give us notice when the easement will actually be developed and made available to the public, because right now it's not available to the public. But the Commission said no, and let the matter rest for a while until 2014. And 2014 is significant because in that year, our legislature gave the Commission an expanded enforcement power, and that is an administrative penalty power. Before 2014, if the Commission didn't like what you were doing on your private property, it could issue notices of violation, it could saber rattle, but if it really wanted to do anything bad against you, like fine you, it had to go to court first, and it had to convince a neutral Superior Court judge of the correctness of its position, and it had the burden to convince the judge of that point. But the administrative penalty power that the legislature granted the Commission reverses that. So now the Commission doesn't need to go to court first. Now the Commission doesn't need to even hold a proper hearing. In fact, for the Lents at their administrative penalty hearing, which was precipitated by the notice of violation, they were afforded no right to cross-examine witnesses. They were given no notice to the people who would testify against them. They were given no right to subpoena. They were given none of the traditional rights that we think are important to protect the due process rights of individuals. Going into the hearing, the staff of the Coast Commission said, we want you, Commission, to issue a penalty order for $900,000. And would you believe that the Commission started a debate among themselves as how that was insignificant, not enough. And ultimately, on their own, the Commission, after having received what I believe is biased evidence, for which the Lents had no opportunity to rebut, the Commission ultimately issued a penalty order of $4.185 million against the Lents. And again, the significant thing is that that is a penalty order that is immediately due and payable, meaning that the Commission does not need to go to court in order to make that enforceable. And so you can see that there are significant due process and other constitutional problems with this framework, and so the Lents sued, and we've decided to take over the case for appeal, and right now we're in the California Court of Appeal arguing, among other things, that the entire administrative penalty framework that the legislature granted the Commission is unconstitutional. Because whenever, as a property owner or as any citizen, you have on the line crushing fines, you deserve more than just a perfunctory hearing, essentially like a land use hearing, where you have maybe 30 minutes to speak and that's it. You have no other ability to develop your evidence, no cross-examination, etc. To make matters worse, where does the money go that the Commission collects through the administrative penalty process? It goes into a violation remediation account over which the Commission itself exerts substantial control, meaning that the Commission both judges your case, and thank you very much. Boy, you're an excellent Jeeves. The Commission both adjudicates your case and then gets to reap the benefits of fining you by deciding where the money will go. It would be as if you were in a court case and the judge, by fining you, was able to use that money to build a new chambers for himself. And so we think for that reason as well, there's a fundamental due process and fairness problem with the Lents case. Unfortunately, this is not the only problem with the Coastal Commission, but it is an important issue because this is the first step that the Commission has taken to expand its enforcement power. The legislature gave it a fairly limited administrative penalty power, and the Commission right now is asking the legislature to expand that power. And so rather than to expand it, it's very important to nip it in the bud. And we hope that this case will not only secure the due process rights of the Lents, but also of other property owners throughout the state. I want to thank you very much for your attention. I apologize if I was a little too legalistic, if I was sweating a little too much, but it wasn't for nerves, just simply for the temperature. And I definitely want to give all of you an opportunity to ask questions, and I also very much want to thank the opportunity to present today to the Liberty Forum.
Okay, we've got a couple that are kind of lined up already. And some are not necessarily on property rights, but related to what you said. This one person wants to know. You talked about precedents and how important that is. Are the very narrow focus of the Roberts Court decisions the benefit is the benefit of precedents being eroded? So the case in point was the Masterpiece Cake Shop was again being sued for not making transgender cakes or whatever the lawsuit is. So there was precedence but it was narrow. What's the impact of a narrow precedence?
Well, by definition, a narrow precedent is not going to have as big of an impact as a broader precedent. And I think the criticism of the Chief Justice's position is that whether a decision is 5-4 or 7-2 or 9-0, the legal effect is the same. If there's a majority, then it's the rule of law. So his desire to have unanimity is really almost a political desire, because I think he wants to show the American people that the court's not as politicized as people think, that in fact judges or justices who are appointed from many different types of presidents can still reach the same result. I mean, I suppose there's a value to ensuring that the public doesn't perceive the court as being politicized, but to me, if 5 justices believe that yes, the law is X, I don't think it seems appropriate to issue an opinion that says the law is X minus 2 or 3 just because you can get more votes for that. Now, sometimes it is true that maybe you can't even get 5 votes for anything, and in that case, I think definitely it's better to have a narrow opinion that commands a majority than to have an opinion that has no majority opinion, because that makes life even more difficult for the regulated public and for lower courts. But definitely, I think there is a problem with trying to secure unanimity just for the sake of unanimity, because it seems to be collapsing the legal obligation of the court with almost a PR concern, which I think is inappropriate.
Thank you. This is I was not aware of this. Maybe you have more information than I do. What is your take on the attacks on Airbnb on coastal properties?
Yes, this has been an emerging issue. I mean, Airbnb itself is emerging as a company, but the concern is that there are many local landowners who don't like Airbnbs because of oftentimes the nuisances that could happen, etc. And yet, this is one of those instances where the Coastal Commission actually is friendly to kind of a free market attitude, in that the Commission likes Airbnbs by and large because it tends to make the coast more accessible, and does so in a way that at least at first blush doesn't seem to harm anybody's property rights by government imposition. But the extent to which Airbnbs and things like that are constitutional or legal, that's something that's still being litigated right now. But it is one of those peculiar instances where you have the Coastal Commission aligning to some extent with property rights advocates.
Yeah. I knew it was just a matter of time. We've had a couple of questions dealing with Senate Bill 50. That's where specifically one person wants to know, what do you suggest we do regarding Senate Bill 50, which would enable the state to override local control over zoning in favor of multifamily condo complexes in suburban neighborhoods?
Well, that's a good question. That's honestly something that I have not studied, that PLF has not studied, in part because there probably isn't a very strong constitutional concern one way or the other. And I will say that traditionally, land use has been a local concern, and that there is a doctrine under our state constitution of local affairs. It's called the local affairs doctrine, which is particularly strongest when it comes to charter cities, although also charter counties have some power too. And basically it's kind of like a federalism principle. Our federal constitution divides some powers with Congress, some powers with the states. Well, under our state constitution, there are some things that are limited to local governments and some things that are limited to the state or that the state can become involved in. So the question here is, to what extent is aspects of land use and zoning, to what extent are those issues of statewide concern? And I think it's fair to say that a lot of affordable housing advocates believe that it is very much a question of statewide concern, because local governments or local groups can limit the supply of housing. The extent to which there's a constitutional question raised, I have to be honest with you, I haven't given much attention to, but certainly that's something that PLF can look at. We have used the local affairs doctrine successfully to vindicate the property rights of local landlords, most recently in a case out of Oakland, concerning the rights of landlords to appeal building code violations that they object to a neutral arbitrator. And so there is some teeth to the doctrine, but the extent to which it can help or hurt in SB 50 is something that I can't quite opine on yet.
Oh, that's fine. Just a note here. Just stop. I thought I felt some cool air. Is anyone else feeling it? No. Maybe it's like, or maybe we're just getting used to it. I do there. This next question is, has anyone successfully argued against a local ordinance of a single-story overlay? Maybe you could explain that, because I don't know what a single-story overlay is.
Well, I think that what the question is getting at is a limitation on the extent to which you can build upwards. But maybe I'm misunderstanding that.
Yeah,
but
okay. Answer that.
But what I can say is that it's very difficult, especially on a theory of takings. Recall the first case I spoke about with Ms. Nick, arguing that your property's been taken and you demand just compensation. It's very difficult to win on those theories when A, you still have the right to exclude the public, and B, you still have some economic value left in your project even after application of the land use regulation. Not impossible, but it's sad to report, but there are many courts that have said that even a loss of 90% in the value of your property because of land use regulation does not qualify you for compensation. So now, that's not universally the case, but definitely it's very difficult unless, as I say, you've lost the right to exclude the public, or if you can say that it's a total wipeout in value. If you have nothing productive you can do with your property, basically open space, then you can also get compensation pretty easily. But otherwise, whatever the rationale for the zoning regulation, if it's not a total wipeout in value, it's very, very hard under takings law to overturn it. Now, maybe there could be statutory arguments that are applicable to the particular type of zoning regulation, but as a matter of constitutional law, very hard to overturn.
And as this occurred to me, I'm going to use a little bit of the moderator's prerogative. You say some of these things, Damon, and they're just so anti-common sense, and we've got 200 people here groaning when they hear them. How does this happen? How do laws get passed? Or are we asleep? Or just a couple minutes? I'm sure it's a very complicated question, but it just seems amazing.
Well, I think there are two significant causes. One is a kind of shift in the legal philosophy that animates most of our legislators and judges. It used to be the legal philosophy consistent with our founding was that the legislature needed a really good reason to hurt anybody's rights, whether they were economic liberties or whether they were First Amendment liberties or rights against search and seizure or what have you. That didn't really matter what the right was. The government really needed an important reason in order to impinge that right. But then starting with the progressive era and especially culminating in the New Deal era, there was a sea change in the courts. And the courts really then began to pick and choose the rights that they really cared about. And basically, in order to save the New Deal legislation, the courts stopped reviewing property rights violations very closely. they may still review very closely things like the First Amendment, but property rights since the New Deal era have received not very much judicial solicitude. So that's one problem. The other problem is, I think, a basic ignorance of economics. Now, I'm not an economics specialist by any stretch of the imagination, but it's pretty clear that so often legislation that's, although well-meaning, that's meant to, say, improve affordable housing or create more affordable housing is going to have precisely the opposite impact. You know, we complain about the high cost of housing. Well, principally, it's just a question of supply and demand. And yet, the basic laws of supply and demand tend not to be given a whole lot of attention, I think, at the legislative level. So I think it's both an understanding of economics and, just as important, a shift in legal culture. And on the legal culture, that's one thing PLF does try to fight back against, not just winning the cases, but also trying to educate the courts about what is, in fact, the best way to interpret the Constitution, and to get the courts to realize that property rights are not the ugly stepchild of our constitutional liberties, that they're just as important as our other ones and should be treated as such.
Yeah. Great point of view. Thank you. This is a very practical question, sort of on the business end. Maybe we need to bring up John. How does PLF share litigation responsibility with others on the same side?
Well,
Sir.
That's actually a Damien question.
Yeah. Okay.
So,
All right,
it depends upon the issue. I mean, oftentimes, you know, we'll get involved in a case wherever it is in the country, but we're not necessarily a member of the bar of every state in the nation. So, in order to litigate a lot of cases, we need to associate with what's called local counsel. But thankfully, there are a number of liberty-loving lawyers out there in private practice who are more than happy to donate their time pro bono to serve as local counsel and allow us to take the lead on these cases. Now, sometimes it's more significant than that. For example, the Dusky Gopher Frog case I mentioned earlier, that was a victory in the Supreme Court last November, that was a real shared effort. We represented the family landowners, and another private law firm represented the Weyerhaeuser Company, which leased the land from the landowners, and we both were in the case from the beginning. We both participated on appeal. We both participated in the Supreme Court, Weyerhaeuser taking the lead, and that was a great case of a real team effort. But typically, when we're involved in the cases, we take the lead, and our local counsel, if we have them, are graciously willing to help us out pro bono, and that helps, obviously, not only us, helps out the clients and our mission.
Can I add something to that, Damien? Well, in a meeting with the president of Pacific Legal Foundation earlier, can you hear me okay? Earlier today, he was talking about Pacific Legal Foundation establishes the law, helps establish, basically take back violations of the Constitution. And then all of the private law firms in the country take the legal precedent that we've established and fight for individual rights. For example, the Nolan case, which is one of the signs back there, has been cited somewhere between 6,000 and 8,000 times in briefs by other attorneys. So that's one of the ways we help sight unseen. We go in and fight the big fight, and then private attorneys just go in and represent individual people, and they say, yeah, I know you'd like to steal their property, but here's the Nolan case, which was a unanimous Supreme Court decision, which specifically says you just can't take people's property and not pay them for it unless what they're doing affects the public in a general way. You just can't say, in order to grant a permit, I want half your property. You can't do it. So that's one of the ways we lead the way and the private firms follow.
Thank you. That's a nice cohesive answer from both ways. This is a very practical question. Our local city council won't let us remove a tree. What recourse do we have?
Well, that depends. If it's on your private property, there are potential recourse. There are obviously a lot of local ordinances that protect oak trees and other trees. There are also some plants that are listed under the California and Federal Endangered Species Acts. So the short answer is need to know more facts, but there may be a remedy, and I would encourage whoever asked that question to send me an email or speak to me afterwards, because it possibly could be something that could be remedied.
Wow, fantastic. Action right here. This is a little bit of a tangent, but it applies as well. Since property taxes are constitutional, Are taxes on the general accumulated capital, as several Democrat candidates have suggested, constitutional? Now, that's out of your way a little bit, but based on your legal mind?
That is so that I think that implies the 16th and my least favorite constitutional amendment, the income tax amendment, because it used to be, income taxes were unconstitutional, and what we did, rather than reinterpret the Constitution, we actually passed an amendment to get that done. I know almost nothing about the 16th Amendment, so I'm not competent to opine. Although we certainly have been involved at PLF in tax issues. In fact, one of our lawsuits way back when, challenging the Obamacare individual mandate, our argument was that because it was a tax under our federal Constitution, it had to come out of the House of Representatives, and the law that became the Affordable Care Act came out of the Senate. We lost that case in the D.C. Circuit, but we do have people on staff at PLF who have done some tax constitutional litigation. So again, just as with the tree issue, I would encourage the person who asked that, if the person's interested in learning more, to let me know. Maybe I can refer that to one of my colleagues who knows more about the issue than I do.
Okay. The next question is, in the case of an expert witness in an ESA case who gets to exclude scientists who they don't agree with politically, what's the recourse on that?
Well, one problem that you have in a lot of these cases when you're suing an agency, whether it's the Coastal Commission or whether it's the Federal Fish and Wildlife Service or what have you, is that administrative law has developed in such a way that the evidentiary opportunities are pretty limited. So if you sue an agency and you say, hey, I want to bring in expert testimony to prove what the agency did was wrong, typically you're not allowed to do that. You're only allowed to rely upon what was in the administrative record, and that means what was presented to the agency before it made its decision. And even if you had an expert testify, say, at an administrative hearing or submitted an expert report as part of the comment period, that's no guarantee that that will even be given any consideration, because when the trial court or the appellate court finally reviews the record, it's not going to look at the record as the agency was. It's going to look at the record giving the agency extreme deference in whom the agency wanted to credit. So it's very hard, even if you think that the agency has discounted your evidence because of a political or other improper motive, it's very, very hard to get that overturned. Now, there are exceptions, and certainly if an agency were to bring an action against you, then typically you do have the right to defend yourself. But if you're suing the agency, it's very hard to get any sort of expert evidence in, even if there's a contention that there was political or other improper motivation in disregarding it.
Well, here's one that's not the least bit contentious. Can we sue the government for violating private property rights of U.S. citizens to protect our borders? Where does that start and stop?
Well, it's actually, PLF has been contacted already by property owners along the southern border who are concerned about eminent domain being abused in acquiring property necessary for a border wall. Now, PLF doesn't take any position on the immigration issue one way or the other, but what we do take a position on is that property rights are property rights. So if there is an eminent domain abuse, then certainly that should be corrected, whatever the rationale is for using eminent domain. Or if someone's property is taken, that property owner deserves just compensation, regardless of the reason for it. So I think the basic answer is absolutely. The Fifth Amendment applies to everybody, and definitely to the extent that there is a border wall constructed or issues about eminent domain or related property rights issues, that certainly is worth investigation.
Okay. So, can punitive damages be levied against parties which violate people's rights so that the rights won't be violated so readily in the future?
Boy, I feel like this is a great law school exam. I'm really getting all that knowledge back. Well, again, not to be a downer, but punitive damages are also very hard to obtain. In fact, any type of money damage is very hard to obtain against the government. And the reason why is this doctrine called sovereign immunity. It's this, yes, exactly. It's basically, it is, I think, an alien notion taken from England, but transferred to this country in a way that doesn't make any sense. So the idea was, in England, the sovereign ran the courts. The king, the judges were kind of the king's bench. So it only made sense that, well, how could you sue the king in his own courts if he didn't want you to? Because he was running the courts. And that notion was sent over, or brought over, to our country in the early days of the founding. But as you can see, that doesn't make a whole lot of sense in our country, because in our country, the people are the sovereign. And so how can they be kept out of courts meant to remedy their own rights? Nevertheless, basically every state in the nation has the rule that you can't get any damages, whether punitive or non-punitive, against a government agency unless the legislature or Congress has specifically authorized that. Now, there is, at the federal level, what's called the Reconstruction Acts, commonly called Section 1983, and that is a law that Congress enacted shortly after the Civil War that does allow you to recover money damages against local governments, at least, when they violate your constitutional rights. Now, punitive damages I'm not so sure about, but definitely you can get money damages that way. But otherwise, it's very hard generally, and punitive, by definition, being even more difficult to obtain than regular damages, would be all the more harder, again, for the same reason that sovereign immunity usually, I don't think, would allow it.
Well, I think Damien's already lost a couple quarts of water up here, so please join me in thanking him for an incredible presentation.
Thank you all again.
This
Thank you
is
very
really
much.
good.